All right, you ready, Stephanie? Okay, let's go on the record in the Winslow case. The record will reflect that we're meeting outside the presence of the jury. All counsel and the defendant are present. The court did receive a recent note from the jury. It reads as follows. Note number 6, as of June 11th, 2019, at 10:12 a.m., the jury remains deadlocked, and it's signed by the foreperson. So we will bring the jury in and make inquiry with respect to that note. But before we do that, the court also received this morning, it was filed just this morning, the defendant's motion to dismiss counts 1 through 3, count 7 and 8 in light of the jury verdict. It was just served here in court this morning. Mr. Owens, did you receive a copy of that?
I did receive an emailed copy once it had been filed, and I received a hard copy when I came down to court.
All right. When I received the motion, the court did some quick research, and the court found the case of People versus Carbajal at 56 Cal 4th 521. I noted that case was not cited in the defense motion, so I emailed it to all counsel. And you received that, Mr. Owens?
I did, Your Honor, and I reviewed it.
All right. And Mr. Carlos?
Yes,
Mr. Watkins?
Yes, Your Honor.
And Ms. Barr?
Yes.
All right. In fact, I was here in court printing it out when Ms. Barr was here, and I mentioned it to her, then emailed to everybody, so there was no ex parte communication. The only other case that was cited in the defense motion is People versus Espiritu. So, have you had a chance to look over the motion, Mr. Owens?
I have.
Are you ready to proceed?
I am.
All right. Who wants to handle this? You, Mr. Watkins? I see you authored it, so go ahead.
Yes, Your Honor. In this case, the jury has considered and found beyond a reasonable doubt that there were no multiple victims. The jury was actually even polled on that point. And so that is their verdict. And so our belief is that under Penal Code Section 1161, the court cannot reorder the jury to go back in and redeliberate as to accounts 1 through 3 and 7 through 8. I understand the Carbajal case, but I don't believe the Carbajal case is on point. That's why I didn't cite it in my moving papers.
Well, it does involve a one-strike out. So the one-strike allegation is what you're focusing on. Is that correct?
The special allegation, the multiple victim allegation.
The multiple victims allegation.
Correct. And in the Carbajal case, they made a true finding on that. And what the court has said, and 1161 says, is that you can revisit and address a true finding on an allegation. But when there's been an acquittal, you cannot. You have to leave it alone. It cannot be readdressed. And there's the difference between our case and the Carbajal case. So in the Carbajal case, they found the allegation to be true. So that is not an acquittal. Here, they found it not to be true, which is an acquittal for all purposes.
Only for one count. So you're essentially stating that because they found the multiple victim allegation not true on count 4, that the other forcible sex crimes need to be dismissed?
Correct, because they said that there were not other victims. No rape occurred of other victims. That's what the multiple victims allegation states. They found that beyond a reasonable doubt and were polled as to that issue. So that is a verdict that was taken by this court and stands. There is no touching it, no readdressing it. In the Carbajal case, the finding was negative towards the defendant as they found a true finding of the multiple victims allegation, although they did not, they hung up on the specific counts. Here, there's been a count, he's been found guilty of it, and the multiple victim allegation has been found not true, which is equals an acquittal on that. So under 1161, it cannot be readdressed. The court does not have the power to rescind the jury back to deliberate that point. So the court must take, and it has already taken, that verdict. And that verdict then spills over to counts 1 to 3 and 7 through 8.
I have, Mr. Watkins, I have no intention of revisiting the allegation with respect to count 4.
Well,
that is they found it not to be true. What you're asking the court to do is expand that finding to the other counts, and your position is it's a mandatory dismissal on behalf of the court. Is that correct?
correct, and it's not that count, that allegation does expand to other acts and other counts. That's what that allegation is. That's a multiple victims allegation. You have to have multiple victims. Find that beyond a reasonable doubt in order to make that allegation true. The jury has considered that beyond a reasonable doubt and has said, no, that allegation is not true. There are not multiple victims here. Therefore, there cannot be multiple victims. Therefore, counts 1 and 3 and 78, which speak about the additional victims, there's been a finding as to that. It has been an acquittal. And the court has taken that verdict, and we cannot readdress it.
And your only authority is Penal Code Section 1161?
And the case we cited, and I don't believe, like I said, Carbajal is of a different factual scenario because it's addressing a true finding.
All right, well, I'm reading Penal Code Section 1161, and it states, when there is a verdict of conviction in which it appears to the court that the jury have mistaken the law, the court may explain the reason for that opinion and direct the jury to reconsider their verdict, and if after the reconsideration they return the same verdict, it must be entered. But when there is a verdict of acquittal, the court cannot require the jury to reconsider it. If the jury render a verdict which is neither general nor special, the court may direct them to reconsider it, and it cannot be recorded until it is rendered in some form which it can be clearly understood that the intent of the jury is either to render a general verdict or to find the facts specifically and to leave the judgment to the court. Where in 1161 do you find support for the position that the other forcible sex crimes should be dismissed? Is it in the wording that it is the intent of the jury that they have rendered an acquittal on the other forcible sex crimes?
Well, the language is when there is a verdict of acquittal, which we have here.
Correct. On count 4, not on the remaining counts. On count 4.
Well, that would make it an inconsistent verdict. If they were to come back and say, we find him guilty on these additional victims, then he does have multiple victims. So now you have a finding of there are no multiple victims, and then you're going to have a finding of yes, there are multiple victims, and that would be an inconsistent verdict. That's why it spills over to those other counts.
But we're not there yet. They haven't reached other verdicts. And the main issue is whether they, I think that your argument might have more traction if they came back with verdicts for guilty for Jane Doe number 1 and Jane Doe number 4 and found the multiple victim allegations to be true, but we aren't there yet.
Well, that would be an inconsistent verdict, and that would be a mistrial. But what I'm saying is...
But the jury's telling me they haven't reached a verdict yet, so they're hung.
They should not be considering it. They cannot go back and reconsider it because they've already made that finding that there are no multiple victims. However, the court sent them back to consider whether or not Jane Doe 1 is a victim, whether or not Jane Doe 4 is a victim. Then there would be multiple victims. They cannot reconsider that because there's already been an acquittal as to the multiple victims part. And that's very specific what 1161 says.
Well, it's not that specific.
Well, I'm quoting from it, and it says, when there is a verdict of acquittal, which we have, the court cannot require the jury to reconsider it. And by sending them back to say, go reconsider whether or not Jane Doe 1 is a victim, go reconsider whether or not Jane Doe 4 is a victim, that is having them reconsider whether or not there are multiple victims.
All right. There's a difference between an acquittal and not finding true an allegation that attaches to a charge. So...
Well, not necessarily. It's all on the same standard beyond a reasonable doubt, and they found the allegation that there are not multiple victims to be not true, and so with the same standard beyond a reasonable doubt standard, so that amounts to an acquittal. And Carbajal even mentions that.
Okay, but if a jury deadlocks on a particular charge that has an allegation, for example, a multiple victim allegation, they can't even address that allegation unless they reach a verdict of guilty on the underlying count. And they haven't done that yet.
They did, as to Jane Doe 2.
Correct.
And they found the allegation that attached to it to be untrue.
All right. And so your position is, since they found that allegation not to be true, that it's a mandatory not guilty finding on the other forcible sex crimes, correct?
Correct.
I think that's what your argument is.
Yes.
Do you have any authority other than Penal Code Section 1161 that would support that position?
And Espiritu, that we also cited in our moving papers.
But Espiritu is not on point.
Well, we believe it is. I believe it supports our position on this. And Carbajal, I believe, is not necessarily on point because Carbajal stands for the position that when the jury comes back with a true finding and it seems to be an error, the court can address it because the defendant then is been found guilty, and you can address that. But when there's acquittal, you can't. And now that there's an acquittal on the multiple victims allegations, the jury cannot be sent back to reconsider whether or not there are multiple victims. And that's what you're having them do by having to deliberate on Jane Doe's 1 and Jane Doe's 4.
All right, Mr. Owens, you want to be heard?
Thank you. Your Honor, I appreciate the court's independent research because People v. Carvajal is directly on point. It deals with the exact one-strike allegation, the enhancement that a forcible sex crime has been committed against more than one victim under 667.61 B, C, E. And it does discuss the double jeopardy issues that are raised by 1161. With all due respect to Mr. Watkins' argument, it is the most analogous and it is the most clear authority that deals with this case, or that would apply to this case. What happened in Carvajal is not just that there was a true finding on the multiple victim allegation. There initially was when they rendered verdicts as it related to a single victim with multiple counts. They found the multiple victim allegation true, submitted their verdicts to the court. The court reviewed them, and in seeing that there was a true finding on the multiple victim allegation, returned the verdicts to the jury for reconsideration with an advisal that that allegation only applies when there's a guilty verdict for multiple victims. They then went back into the deliberation room, and then what Mr. Watkins has failed to acknowledge is they then found not true the allegation of multiple victims while not making any specific findings, basically becoming deadlocked as it related to the substantive crimes for the other victims that had been charged. That's what we have here. And we have a jury that has rendered a verdict on the allegation while not making a substantive finding of guilt or not guilty on the other charged sex crimes. So Carvajal clearly is on point. Carvajal also acknowledges that it goes so far as to not bar retrial on the balance of the counts as well as the multiple victim allegations that may apply at that point. So I'm asking that the court deny the motion to dismiss on the grounds stated and not only make a finding that while the verdict that has been received and recorded must stand, make a finding that there is no bar to retrial on the balance of the forcible sex crimes against Jane Doe 1 and Jane Doe 4.
All right, Mr. Watkins, you want to respond?
Your Honor, he's partially right. Carvajal is very specific, and in Carvajal, the special allegation was not supported because they didn't find the underlying crime. That's not what we have here. Here we have a supported allegation found guilty on Jane Doe 2. So we have a supported allegation. The allegation was considered by the jury, and that allegation was found not true. That right there is a complete verdict taken by this court that stands.
Okay, correct. But if the multiple victim allegation is just that, it says they have to be convicted of multiple victims in the same case or proceedings. They have not rendered a verdict. If they would have found them guilty of another forcible sex crimes, I think the allegation would have been different, obviously. But you're equating a not true allegation because they're hung on other forcible sex crimes with a not guilty verdict on the other remaining Jane Does, and it sounds like they're not going to come back with a not guilty verdict because they are hung on those counts. So how do you, your argument is inconsistent. The jury's finding is not inconsistent with what I think they're about to tell us, that they are hung on those other forcible sex crimes. Your argument is inconsistent, but what they're about to tell us, I don't think is.
Well, I'm speaking, I don't know what's going to happen. I kind of can predict what's going to happen.
They're going to say they're not able to reach verdicts on those other forcible sex crimes.
Well, our position is, as of yesterday, when they came and rendered that verdict and did not render verdicts on the other counts, the court had no authority then to send them back into the deliberation room to reconsider those counts because it was an effective acquittal on the multiple victims allegations. They cannot go back and deliberate to see whether or not there were multiple victims at this point.
I understand. Okay. All right. Thank you very much.
If I may just
Yeah, do you want to add anything else, Mr. Owens?
I do.
Although I'm about to rule in your favor.
I understand, and I'm simply just going to ask for a pinpoint citation to make sure that it's in the record. When Carvajal says specifically that in circumstances where a jury has authority to consider and decide an allegation, the jury's verdict, even if erroneous, may bar a retrial on the allegation under settled principles of double jeopardy. As we now explain, however, the first jury in this case had no authority to consider the multiple victim allegation. Once the jury had deadlocked on counts involving ZC, which would be one victim, the jury could not have returned a valid verdict on the penalty allegation, and double jeopardy thus did not bar retrial on the allegation.
Right, that's exactly what I just said.
And I wanted to make sure that it was very clear as to the citation from the California Supreme Court, which also cites back to authority from the U.S. Supreme Court interpreting the double jeopardy provisions of the Constitution. Simply put, the jury in this case, based upon where they were yesterday afternoon when they rendered verdicts on 4 of the counts, believed their job to be done, essentially, and that they were not going to be able to reach verdicts. And I would submit to the court perhaps erroneously made a finding on the special allegation because they couldn't have reached it if they hadn't reached verdicts on the substantive counts.
Correct.
So procedurally, it actually makes much logical, intuitive sense that they simply filled out that allegation because they had not made findings on the others. And now we have direct authority that allows retrial on those other counts, and perhaps even the jury to have potentially made findings as to those other counts, and then we could have dealt with the inconsistency if it ever came out.
Correct. Essentially, it turns out to be a gift to the defendant that they were able to reach a finding on that one strike allegation while remaining hung on the other forcible sex crimes. It is a benefit to your client, Mr. Watkins.
I understand, but my position is you're reading, and the prosecution is reading well too much into this jury and what they're thinking and what they're doing. The bottom line is in Carbajal, the verdict was erroneous because it was not supported. But it's not.
You're stating that the not true finding on the multiple victim allegation is a statement by this jury.
Correct.
That he is not guilty of the other forcible sex crimes.
Correct.
Isn't that reading too much into that not true finding on the allegation?
It's a verdict that was taken by this court, and it stands as an acquittal to multiple victims. And the problem with Carbajal is it was an erroneous verdict, but the verdict that the court took yesterday was not erroneous. It was supported by the underlying charge and a not true finding on the allegation. Unlike Carbajal, which was reversed. It was a true finding on the allegation, unsupported by no finding on the underlying allegation. And that was an erroneous verdict that the court had to deal with. Here, we do not have an erroneous verdict.
Okay.
We have a valid verdict.
Understand. Okay. The court is going to deny the motion to dismiss. The finding with respect to count 4, the multiple victim allegation, is not inconsistent with what we are about to hear, I think, from this jury. The allegation that it's a multiple victim allegation, attaches to a number of the charges, including counts 2, 3, 5. Yeah, 2, 3, and 5. So those allegations do not require the court to dismiss the other forcible sex crimes, and there's no authority to support it. In fact, Carbajal argues against it, and Espiritu is not on point, the case that's cited by the defense. That is not on point. Now, there was an argument yesterday and you mentioned it today, Mr. Watkins, that the court should have accepted the deadlocked jury decision yesterday because they had indicated they were deadlocked. Although upon inquiry, when I said, "Are you hopelessly deadlocked?" they said, "Well, for now." And I said, "Well, would additional deliberations perhaps allow you to reach a verdict?" And they said, "Yeah." So I sent them back. Then they sent the other note out, and we had to deal with that alternate juror issue. And I will note that they have been deliberating now for just under 2 hours, which is good. I mean, they have been out there deliberating as they have been for a long time, but under People versus Young, and we were back in chambers yesterday having an informal discussion. I cited the People versus Young case at 156 Cal. 4th, 1165. In that case, the court said, when faced with questions from the jury, including that they have reached an impasse, a court must do more than figuratively throw up its hands and tell the jury it cannot help. It must at least consider how it can best aid the jury. And that's what the court was doing yesterday by asking them if they needed additional instruction, additional clarification, and the court was certainly open to allowing additional argument by the prosecution and the defense if they were able to focus us on a certain area of law that was causing them trouble. And that's permissible under the rules of court 2.1036. It gives me three options, and that's one of the options. So the court feels it was well within its discretion under People versus Young to not just throw up its hands, especially after we've invested a month in this trial, and this jury has been here for 5 days deliberating, but it all appears for naught because they are unable to reach a verdict. They are not requesting additional instruction at this time. I'm going to inquire when they come out. So the defense motion is denied, and we will bring in the jury. Are there any alternates that showed up?
Yes, sir.
Go ahead and bring them in. You're the only alternate that was out there? All right. Thank you again for being here today. The jury's coming in just a moment. I failed to address the other issue that you had asked the court to address with regard to double jeopardy and retrial. I'll deal with that in just a moment.
Thank you, Your Honor.
All right. We are now on the record in the presence of the jury. The court has received juror note number 6 from juror number 6. It reads as follows. As of June 11th, 2019, at 10:12 a.m., the jury remains deadlocked, signed by juror number 6. So juror number 6, is it your considered judgment that the jury is hopelessly deadlocked?
Yes.
All right, and that's with respect to the remaining counts 1, 2, 3, 5, 7, 8, 11, and 12, correct?
Correct.
All right, now we kind of went through this a little bit yesterday. If the court were to ask you to continue to deliberate, do you believe there's any reasonable possibility that the jury might be able to arrive at verdicts on one or more of those counts?
No.
Is there anything else the court can do to assist the jury in reaching a verdict, such as reading of further instructions, clarifying instructions, or perhaps even reopening it for argument by counsel?
Not at this time.
All right, let me ask you this. With respect to the remaining counts, how many ballots or votes have been taken by the jury?
Everyone has voted.
Everyone has voted more than once?
Everyone has voted on everything.
Okay. Now, I'm going to ask you a question. I want you to listen carefully to the question, because when you answer, I only want 2 numbers. I don't want to know which way the verdict was leaning or which one was in favor, but are the numerical breakdowns for all remaining counts the same in terms of the vote by the jury, or are they different? Yes or no? Are they the same?
They are different.
They are different. Okay. Do you have a recollection as to the split on each of the individual counts?
Not all of them.
All right. Well, let's start with counts 1 through 3. Those involve the allegations with respect to Jane Doe. So counts 1 through 3, are the numbers the same for all 3 counts?
Yes.
All right. Now, I don't want to know which way the jury was leaning in terms of guilty or not guilty. I just want 2 numbers. What was the last vote with respect to counts numbers 1 through 3? 2 numbers. If you need some help from your...
Are you referring to the last person who voted?
No, the last. So I want to know if it's 11 to 1, 6 to 6, 8 to 4.
So it's 5 to 7.
5 to 7 for counts 1 through 3. All right. With respect to count 5, which is the sodomy by force against Jane Doe number 2, what are the numbers for that? Just 2 numbers. If you need to ask other jurors for some help, you can.
All right. It would be 3-9.
3-9 on count 5. And then with respect to counts 7 and 8, those refer to Jane Doe number 4 from 2003. Are the numbers the same for that?
They're different.
Okay. With respect to count 7, which is the forcible rape involving Jane Doe number 4, what was the breakdown on that?
10-2.
And then with respect to count 8, rape of an unconscious person involving Jane Doe number 4, what was the breakdown on that? The 2 numbers. Again, rape of an unconscious person, Jane Doe number 4 from 2003.
84.
And then with respect to counts 11 and 12 involving the incident on February 22nd, 2019, willful cruelty to an elder for count 11, and battery against an elder, are the splits the same on those two charges?
Yes.
And what are the two numbers for those?
10-2.
10-2, okay. And has there been any movement since you went back, since last night? Have those numbers remained? Everyone's shaking their head, so it sounds like, has there been any movement at all, yes or no?
Yes.
There has been movement.
Just one vote didn't change.
Okay, and which count was that?
Count 8.
Count 8. Okay, so 8-4 was the last tally then, correct?
Correct.
All right. Well, you've been at it 6 days now. It's your considered judgment that further deliberations will not result in a verdict, is that correct?
All of us agree with that.
Okay, all right. I'm going to ask all of you if you're in agreement, so I'm going to ask the following questions, starting with you, juror number 1. You've heard everything that the foreperson has had to say. Do you agree with the foreperson that in your considered judgment that the jury is hopelessly deadlocked and the jury is unable to reach a verdict, yes or no?
Yes.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 7? Sir?
Yes.
Okay, I already skipped 6
I
because you already
realized
told
that at
me.
the end.
Okay, so the answer is yes for juror number 7. Juror number 8?
Yes.
Juror number 9?
Yes.
Juror number 10?
Yes.
Juror number 11?
Yes.
And juror number 12?
Yes.
All right, it now appears to this court that this jury is hopelessly deadlocked with respect to counts 1, 2, 3, 5, 7, 8, 11, and 12. I now declare a mistrial, and I will discharge the jury from further service in this case. I have a concluding instruction that I need to read to you. You have now completed your jury service in this case. On behalf of all the judges of the court, please accept my thanks for your time and effort in this matter. Now that the case is over, you may choose whether to or not to discuss the case in your deliberations with anyone you want. I know I've kept you under the admonition for quite some time now. I've told you can't talk to your spouse, family, friends, spiritual advisors, or therapists and so forth, that you can't talk about the case with anybody. You are now released from that admonition. And you're going to go back and tell your employer and your family where you've been for the last month. You can finally tell them. I want to remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about this case. I don't think you're going to be offered any money on this. I have to instruct you on that charge because of the O.J. Simpson case years ago. This law was passed that I have to instruct you with respect to that. Let me tell you about some rules the law has put in place for your convenience and your protection. The lawyers in this case or the representatives may now talk to you about the case, including your deliberations or your verdict. Those discussions must occur at a reasonable time and place, and they can only occur with your consent. Now, typically, you would go out in the hallway and maybe meet with the attorneys outside. However, in this case, what we've done is arrange for you to go back to the jury room. In cases such as this, where a jury is unable to reach a verdict, it is very helpful for the attorneys to speak with the jurors and assess the likelihood of possibly retrying the case on the counts for which you were unable to reach a verdict. So you can talk to the attorneys back in the jury room if you want. I will tell you it is very helpful for the parties if you choose to do so. But that's your choice. If you don't want to stick around, you don't have to. So in just a moment, I'll have Manny take you back to the jury room, and the attorneys can go back there and talk with you about your deliberations and about your findings. Also, at times involving high-profile cases, the media wants to interview some jurors and find out what their thoughts. I've been told that nobody wants to speak to the media. Is that correct? Does anybody want to speak to the media about their findings? If so, raise your hand. All right, nobody has raised their hand. I will also tell you that any discussions with the media has to be done with your consent as well. If somebody chases you out to your car in the parking lot and asks you questions and sticks a camera in your face, you just tell them that you don't want to talk about it. And if they persist, you let me know, because they cannot engage in harassment of jurors like that. And anybody who violates these orders could be fined for violating a court order. I'm going to order that your record of personal juror identifying information be sealed pending further order of the court. That includes your names, your addresses, and phone numbers, because we have all that information, and it can only be disclosed on a further order of the court. Let me tell you how that would work. And I gave you some examples at the beginning of the case. Remember I told you about that juror who was posting things on Facebook during the course of the trial, and nobody knew about it? And there was that juror who was sending tweets from the jury room updating everybody about the votes and so forth. Those two jurors had to come to court and testify as to what they were thinking. And that was a situation where the court found good cause to release the jurors' identifying information only to the attorney so they could issue a subpoena. If there is ever a request to have your personal juror information released, they would have to come to court, make a prima facie finding that there is good cause to release that information, and then the court would set a hearing in which you would be notified, and you would be able to come to court and oppose the motion if you want. Now, I want to tell you that on the number of years I've been involved in the legal justice system in cases I've personally handled, that has never happened. So I don't want any of you to go home and lose sleep over this tonight, wonder if your personal identification is going to be released, because it is not. I'm just telling you this because if there's a motion to disclose it, you will hear about it. So if you don't hear from us, and I don't think you will, don't worry about it. Okay, so again, I don't want you losing sleep over this case. I imagine some of you probably already have lost sleep over this case. It's a very emotional case. It required a lot of attention to detail. It required a lot of hard work on your part. And I know that a lot of jurors, when they are unable to reach verdicts, feel as though they failed the justice system, and you have not. This is the best part of our justice system, having jurors like you who are willing to come in here and listen to cases like this. We've had other judges that come here and look at our justice system from other countries, and they say, how do you get jurors to come in here and serve on this trial? And we say, well, we send out subpoenas and summons, and they show up. And these other judges say that would never work in our country because no one would ever show up. So all of you have done your civic duty by showing up, and that's really the pillar of our criminal justice system, is having citizens like you appear and listen thoughtfully to the cases, listen to the law, listen to the argument, and render verdicts. Now, you were able to reach 4 verdicts, so I don't want any of you to feel like you failed in any way. It is not uncommon to have jurors that are unable to reach decisions. So please, don't feel as though you failed the system. You did your job, you did it diligently, you did it honorably, and I can't thank you enough. I'm sincere when I say that. I know we take time away from your family, your friends, your jobs, the golf course perhaps for some of those who are retired, and you come in here and you sit here for hours and deliberate for hours. You truly have the thanks of the court for spending the time you did on this very, very important case. And also, under the media scrutiny this case was under, I know you had to be extra diligent in avoiding any media coverage. So I really, really appreciate your service in this case. So what we will do now, you can retire back to the jury room. You are excused, and the alternate can go with you as well. And if you could just wait 5 or 10 minutes for those, hang on, for those of you who want to talk to the jurors, just wait talk to the lawyers, wait 5 or 10 minutes, and then we'll be back in there with you. For those of you who want to leave right away, Manny will escort you out of the courtroom. We'll take you out the back door so you can avoid all the circus out in the hallway, okay? Again, thank you all very much. You are now excused. Thank you. Thank you. All right, the jurors have now been excused and have left the courtroom. I failed to address the request that you made, Mr. Owens, to make a finding that they're not barred from, there's no bar for retrial. Is that what you're asking the court to do?
Your
On
Honor,
the multiple victim allegations?
Yes, Your Honor, and that I would like to just make sure that if there was going to be a motion to dismiss as a corollary afterwards, by the defense that the court deny that motion. But if it's going to be addressed in some other way, perhaps under 1385, then we can respond in writing and
Okay.
address it at that time.
All right, well, the court does not need to make a finding yet as to whether or not retrial is barred by double jeopardy, because that is an issue that needs to be addressed prior to the next trial, if there is another trial. So we can address it at that time, it's just untimely at this point. So with respect to the next hearing, do you want to set a hearing for tomorrow morning, a status conference?
Your Honor,
And see where how we want to proceed? Tomorrow morning at 9?
We have a brief moment, Your Honor.
Yes. In fact, let's go on recess for a moment. Let me grab the court's calendar. It's in chambers.
Are the jurors still waiting for us? 5 minutes, they said?
Yeah. Do you want to go back and talk to them now?
Yeah, please.
All right, and then, so we'll hold Mr. Winslow here.
Okay.
You can go talk to the jurors now, and we will be in recess, and we'll come back and say 10 or 15 minutes and set a future date, perhaps tomorrow morning at 9.
Perfect.
All right, we're in recess.